Bismillahirrahmanirrahim. Assalamualaikum and a very good day to the esteemed Dr. Suzy Fadila. I am Muhammad Syamil with metric card number 2017829. So this is my case review video for the case of Merong Mahawangsa Sdn Bhd and another and Dato Shazryl Eskay bin Abdullah reported in the year 2015. So the discussion for this case will cover the topic of illegality. So moving on to the first part of the discussion, which is the parties involved. This is the appeal case where there were two appellants, which were the first appellant was Merong Mahawangsa Sdn Bhd and the second appellant was Surya Kalbu Sdn Bhd. The respondent in the case was Dato Shazryl Eskay bin Abdullah. So moving on to the facts of the case, this case was about the bridge planned by the government of Malaysia to replace the Johor-Singapore Causeway. So the appellants had requested the respondent to render his service to procure the award and the execution of the project from the government, since the respondent has a close relationship with the government of Malaysia and Dato Sri Megat Yunis, who was in charge for the project. So the appellants agreed to pay 20 million ringgit to the respondent for the services. So on 3rd July of 1998, the letter of undertaking was signed. The respondent obtained and secured the bridge project to the appellants. So however, on 11 August 2003, the bridge project was awarded to another party, which was Gerbang Perdana Sdn Bhd. And again, on 12 April 2006, the government of Malaysia wholly scrapped the bridge project. So later, the appellants refused to pay 20 million as they claimed that the letter of undertaking could not be effective as the consideration given was illegal. So since the case was decided at the federal court, so what was the decision made by the previous court? The High Court, which was the trial court, had ruled that the appellants need to pay the sum of 20 million to the respondent, while the decision made by the Court of Appeal later was contrary to the decision by High Court. So the Court of Appeal held that the appellants no need to pay the money. So what about the federal court? So before jumping directly to the decision, what issue occurred and is relevant in our discussion today? So the issue was whether the consideration given by the respondent was opposed to public policy, illegal and therefore unenforceable. So to know the answer to the issue, let's move on to the arguments made by the parties. So there were other arguments, but we will be focusing on the arguments relevant to our discussion today regarding illegality. So the first one is the argument made by the appellants. So the argument made by both appellants was quite similar. So the argument was the accepted procurement of the bridge project on the account of the respondent's close relationship with the government of Malaysia, and Dato Sri Megat was against public policy, and the letter of undertaking was illegal and void. So there were actually a lot of cases cited in the case, but these two cases below got much attention. So the first case cited was the case of R.N. O'Brien, reported in 2009. So this case was about the defendant committed an offence contrary to section 121 subsection 1 clause D Criminal Code of Canada. So he used his influence and close relationship with the minister to get a faster appointment for a certain service. However, the court held that the activity in issue in this case harms public confidence in the integrity of the public appointment process. So a process must be conducted in a fair, open and transparent manner. So another case was the case of Telecom Resources Limited and Guinness Investment Co. Limited, reported in 2003. So this case had quite similar facts with our case. So this case was about the claimant who had acted as an intermediary between a company and the government of Guinea. So the claimant claimed fees allegedly due. The defendant argued that the officers of the claimant had stated that they had a special relationship with the government of Guinea. This because the claimant had agreed to use influence and relationship with the government to obtain for the defendant an interest in bauxite plantation in Guinea. So such agreement was illegal by law of Guinea. So the court held that it was contrary to public policy that a person should be hired for money and valuable consideration and use his position to get benefit from someone. So the court dismissed the claim made by the claimant. So moving on to the next part, which is the arguments or the counter arguments made by the respondent. So the respondent in this case alleged that he had rendered the services to the appellants, which he had obtained the tender and secured the bridge project, elevated the second appellant equity from 20% to 60%. So the respondent also claimed that there was no illegal consideration in the agreement. So these two cases below were cited in the argument, which were the first one was the case of Wong Hong Leong David and Razman bin Adnan, reported in 1995. So this case was about the appellant sought the assistance of the respondent who said he knew the Menteri Besar of Selangor to expedite the conversion and subdivision of his company's land. Later, the appellant also agreed to pay RM 268,888 for the fee and add another 100,000 for the respondent's assistance. So this case also had quite similar facts with our case. So what was the court held? So the court held that the consideration given was acceptable and did not oppose any public policy. So now the case was the case of Teresa Chong and King Cohen and Co. reported in 1976. So this case was about the plaintiff being the members of the Stock Exchange of Malaysia and Singapore, which is governed by its vice laws. So the vice law provided that a member firm to appoint a remisier whose name is required to be registered with the stock exchange. So any member found guilty and violating the laws rules is liable for a fine and suspension of membership. So the appellant entered into an agreement with the respondent to engage her as a remisier without her being registered was void as being contrary to public policy. So the court held that the contract does not fit into any of the traditional pigeonholes, thus the contract between the party was not illegal and it's not affect the public at large, but only the members of the stock exchange. So moving on to the decisions. So what was the decision by the court? The court held that the services rendered by the respondent was not contrary to public policy. This because the respondent affirmed his pleaded facts and provided further details on his influence and the manner in which he exerted his influence and convinced those ministers to obtain favorable decisions is destructive, sound, and in a good administration. So the claim made by the appellants where it opposed public policy was dismissed and it did not affect the public at large. It was also proved that 20 million ringgit was the consideration for the service rendered by the respondent is acceptable. So the federal court set aside the orders of the Court of Appeal and appeal allowed. So what is the ratio decedenda in the case? So the ratio is the first one is Section 24, Subsection E of Contract Act 1950. So which stated that the consideration or object of an agreement is lawful unless the court regard it as immoral or opposed to public policy. However, in this case, it was proved that there was no opposed to any public policy, as what has been stated in the case of Teresa Chong and Kim Kon and Co. reported in 1976, where it defined it will be illegal if it affected the public at large. So in this case, it does not affect the public at large. So another ratio is the maximum used in the case, which was ex dolo molo non-origin action, where idea of what is public policy. So it defines public policy as the principle which declares that no man can lawfully do that which has a tendency to be injurious to the public welfare. So another thing is why the judgment made in the case of Techron Resources Limited and Union Investment Co. just now was different from our case, because of the public policy and standard of morality is different from one country to another country, as was stated in the case of Tengku Abdullah Ibn Sultan Abu Bakar and Muhammad Latif bin Shah Muhammad, reported in 1995. So moving on to the next part, why this is important. So this case define and of how Section 24 Subsection E of Contract Act really works, as it cited a lot of cases in it. The case gives more elaboration on what is public policy, in what situation is opposed and did not oppose. So it can be said in general that something that did not affect the public at large will not be considered as opposed to public policy. And the last one, of course, the bindingness of the case, since the case was decided in the federal court. So another thing is the case also relate and strengthen the principle of contract law, where it's Section 24, Subsection E of Contract Act 1915 about the public policy. And it also derived that the public policy in one country differs from that one of another country. So moving on to the next part is comparison with other cases. So I cited two cases here. The first one is the case of Teresa Chong and King Kong and Co. 1976. The decision made by the court in this case derived a very clear and bold answer to the question regarding public policy. So this case has clearly mentioned that a contract will be considered illegal if the object or the consideration in the agreement is opposed to the public policy, which affects the public at large. So to compare with our case, there are no difference. They are similar because of the effects of the consideration made by the respondent. In this case, was not against public policy since it did not affect the public at large. So another thing is, if the bridge project is complete, it is for the benefit of for the people and the public. So another case in the case of Dato Ong Kihu and Sinium Anak Mutip reported in 1993. So this case was held illegal as it was an agreement tending to injure the public service. So the judge in this case stated that it is clearly against public policy if a member is deprived of the remuneration, since it would be hard for him to function effectively as a member without financial problem. So this case is different and can be compared with our case because it affects the public at large. So the last part of my presentation today is that what is my personal view regarding this case. So I have the same standard and decision with the trial court and the federal court decisions during reading the case, even before reading the decisions part. So the principal rely on this case exactly follow the principle that I learned in the class. This helped me get a better understanding about the topic of illegality. The word used in the report also was quite easy to understand, and this case was interesting to read since there was a different decision from the trial court, the Court of Appeal, and the federal court. And I can also see that it is not easy to prove illegality in contract to make a certain contract void, as the court will really judge and see all the evidence provided. So I guess that will be all from me. Thank you, and Assalamualaikum.